Hi, I'm Mason Fitch. I am a health privacy lawyer, and this is Ask a Lawyer. Today, I'm going to answer commonly asked questions about marketing and data privacy when HIPAA rules do not apply. Who regulates health data outside of HIPAA, and what constitutes as health data? So when you think about health information, most people probably just think about HIPAA, and it's surprising that there are different types of health information. In fact, over the past couple of years, this has been one of the biggest areas of legal development. We have both federal agencies, namely the Federal Trade Commission, regulating health information, as well as state attorneys general. So the FTC generally regulates trade practices. Their Section 5 enforcement authority relates to deceptive trade practices or unfair trade practices. Under both of these prongs, the FTC has developed a lot of guidance and a lot of enforcement action relating to health information, particularly over the past couple of years. So they define health information broadly. It's a bit of an amorphous definition, but generally something relating to a condition or a diagnosis that relates to an individual. Similarly, state attorneys general can pursue enforcement actions under the same type of Unfair and Deceptive Trade Practices Act that the FTC follows, but they also have enforcement authority under state comprehensive privacy laws, which govern sensitive personal information. The definition of sensitive information can vary state to state, but generally we're working off the same definition of something that reveals a condition or a diagnosis of an individual. So, if you're advising a company, if you're in-house, this is a broad universe of information that far exceeds what HIPAA governs that you have to think about. And you have a bunch of regulators. At this point, there are probably 30 different regulatory bodies that care about this type of information. So it's an area of significant risk. Given the number of laws and the number of regulators we're dealing with here, how do marketing teams approach this patchwork of laws? Do you follow a strictest state model where your practices align with the most restrictive laws out there, or do you adopt a more flexible state-by-state approach? Obviously, a state-by-state approach is difficult when it comes to marketing, in particular online marketing, because you don't always know who is where. There are ways to infer a person's location and adjust your practices based on that. But that can get a bit unwieldy. What I typically see is that marketing teams will have a couple different approaches. They'll group different states into different categories, those states with kind of similar state laws. So one, you have your states where you need consent before processing sensitive data. There are states where you don't need consent before processing sensitive data. And there are some states where it's become really difficult to use health data at all. So typically what I see is dividing into broad categories like that, which does a good balance of addressing your risk while still enabling marketing opportunities. So what is Washington's My Health, My Data Act, and why does it matter? My Health, My Data was the first of its kind of law coming out of Washington state that governed consumer health data. You might think to yourself, I don't process health data. I own a gym or a grocery store or something like that. But if you read the definition in My Health, My Data, it's actually extraordinarily broad and can reach organizations like grocery stores, or in particular gyms or health and wellness sites. The definition is broad is one thing, and two, its applicability is broad. This is a relatively new law, so we'll see how it plays out in enforcement activities. But if a strict reading of the statute extends the law to processing activities that occur within Washington state, so arguably that includes any processing that involves servers located in Washington state. And between Microsoft and Amazon's presence in Washington, many people could be processing their health data in Washington, regardless of where they're actually located. So it's a very broad law. It could apply to a lot of people. And one of the most important reasons why it matters, aside from general compliance, is that this law has a private right of action, which means that individuals can actually sue. So not only are we dealing with 30 regulators or however many exist in the health world, but millions of potential plaintiffs and eager plaintiffs' attorneys. So what did the Healthline case coming out of California teach us about purpose limitation, and what are the implications for health marketers going forward? So first, Healthline was an enforcement action in California under the CCPA, where a health informational website was alleged to have pixels that were collecting information about articles that an individual might read. And for example, maybe an article was, recently diagnosed with diabetes, ? Here are 5 things you need to know. So the allegation in the Healthline case was that marketing pixels, or various types of pixels, were recording or determining that a person saw a particular article and that may have been used for advertising purposes. So that was the case. The enforcement tool here that the California regulators used was called the purpose limitation test, among other allegations in the enforcement activity. So the purpose limitation test its use was interesting for a couple of reasons. First, it was the first time this particular prong of the CCPA requirements was used in an enforcement activity. Second, it's just a subjective test that makes compliance a little more difficult. It's no longer just about notice and consent. The purpose limitation test requires that data collected for one purpose not be used for another purpose unless it reasonably aligns with a consumer's expectations, right? So when we think about, can we use this data for marketing, or what type of data can we use for marketing, the purpose limitation test requires that we kind of perform that subjective analysis of can this data be used for marketing, and does it align with the original purpose for which the data was collected and a consumer's expectations, given kind of all the context and the privacy policy or other notices or just the type of site that the data was collected from. So it's a much more complicated analysis, and it's a stronger tool because regulators can take a point of view here as to whether or not something aligns with expectations. So a strong tool, an important tool, and one that's going to matter a lot. So what does the Healthline case mean in terms of going forward? It doesn't really change what we already knew, in that being that regulators care about health information, health adjacent information, and in particular, the use of health-related information for marketing purposes. It's novel in that it introduced another tool, but it's not a surprise because we already knew that regulators care deeply about how this type of information is used. It just means going forward, health marketing groups need to continue to be careful. You need to be intentional about how you use data, and you need to know what you're collecting. Because this test in particular, for example, the question is, are we using data different from the purpose in which it was originally collected? And often for advertising purposes, the answer is going to be yes. If a website collects wellness, symptom, insurance, device usage data, when does that become regulated, and what type of data raises the highest risk? So the answer is the data becomes regulated as soon as you have it. So for example, if you have browsing activity on a health-related site, if that becomes collected or logged at any point in time, whether it be logged directly by you or critically by one of your service providers, which is most often how it's collected in the first instance, it becomes regulated at the point of collection. If we're looking at state comprehensive privacy laws, for example, many require consent prior to processing, and collection is a type of processing. So it becomes regulated as soon as you can see it, as soon as it's logged. In terms of what raises the highest risk, so what we're really looking for when we're talking about tracking technologies and healthcare there's two aspects to consider. One is identifiability. How confident are you that the person that the data relates to is a specific person, and who is that person? So, we think about, is the browsing activity logged from a logged in experience or a logged out experience? And what type of data can be used in the logged out experience to infer who that person is? Because as I'm sure most marketing teams know, even logged out activity, when you don't know a person's username or an email address, that data can pretty easily be associated with more identifiable information. So one, high risk when the more identifiable a person is, and two, high risk the more the browsing activity tells you with certainty that that person has a particular condition or diagnosis. So for example, if you're on a logged out site reading an informational article about diabetes, it's, you could argue that you don't know that that person has diabetes. They could just be curious. They could be reading on behalf of a family member. They could be doing research for a school project, right? So there's a little less sensitivity there, but still, not non-zero sensitivity. But compare that, for example, to a checkout page for a person who requires a prescription. There, you are much more certain that the person making that purchase is the person who has that condition or diagnosis. So regulators are going to look very, very carefully at that type of data for advertising purposes. How risky are integrated patient journeys, like routing from a brand site to a telehealth or pharmacy provider, when tracking pixels or analytics tools are active? And can that data become PHI? So anytime trackers or other pixels are present on a site that relates to healthcare, there's a risk that information is sensitive information, or at the very least that it's the type of information that a regulator is going to care about and pursue a Healthline type enforcement action where it wasn't necessarily sensitive information by definition of the law, but still data that a regulator cares about and is going to apply something like the purpose limitation test to. So anytime we're on any health-related site and there are pixels and trackers, regardless of where a consumer is in the funnel, it's something that we need to care about. On the question of whether or not something can become PHI, this is going to be an entity by entity analysis. It requires legal determinations, but in general, if an entity is a covered entity or a business associate under HIPAA and they're exposed to health information, there's a risk that becomes PHI. And the Department of Health and Human Services has actually put out guidance about how to determine whether or not certain browsing activity is PHI. So this, when you're dealing with a HIPAA regulated entity, this is an area of extreme caution for marketing teams. What are the legal risks when health-related organizations are using pixels or other tracking technology for marketing purposes? There's a lot of risk, right? If we're working with data that is determined to be sensitive information or more sensitive information, even if it's not, strictly sensitive information under a law, there's a lot of considerations that flow from that. Most practically or most obviously, in many states, if you're dealing with sensitive personal information, those states' comprehensive privacy laws require that you obtain consent before processing the information. Right, so there's a bevy of regulatory requirements that are going to come when you collect this type of information for advertising or marketing purposes. One is you may need consent. Two is traditional privacy principles, right? You're going to need to provide notice. And when you're dealing with more sensitive information, for purposes that aren't really typical or perhaps typical in this space, you might need more notice than you're used to giving for the collection of other types of personal information. So, the main risk is that you're not complying with the many requirements that come from state privacy laws that attach once you're processing sensitive personal information, namely consent. But as we've seen, for example, in the Healthline case, it's not just about consent. There's also sort of a more subjective analysis of, is this processing activity appropriate given individuals' kind of reasonable expectations in relation to that data. So our session replay tools, chat widgets, embedded videos, do these create legal risk? The simple answer is yes, they do, and they can. Anytime any tool is exposed to or has the chance to collect sensitive information, that should be considered legally risky. And you and your teams should approach any type of tool like this with intentionality. You need to be cognizant of what type of information this tool is collecting, for what purpose, and who it can be disclosed to. And this is true even if these tools aren't collecting traditional, strictly personally identifiable information, such as a name or an email address. One of the many lessons we've learned from privacy enforcement over the past years is that type of information isn't required for browsing information to be considered identifiable or to be considered personal data and thereby governed by these state privacy laws. Something like an IP address or a device ID, given the advertising ecosystem we're in, can be used to identify someone directly. So we need to be very cognizant of what type of information is collected. If it's something as simple as an IP address, it's likely going to be personal data. And then attached to that IP address, is it a session replay of a person browsing a health website? What information can be gleaned or could be gleaned from that browsing activity? And when you're dealing with healthcare, if it's something as simple as, again, browsing a health information site, that's something that regulators are going to care about, which makes it legally risky and something that requires quite a bit of intentionality when you're integrating that tool onto your site. So if ad platforms restrict health-related targeting, how can marketers still reach patients without crossing privacy or platform rules? So first, this isn't an if question. It's already happening. We're seeing ad platforms restrict health-related advertising pretty widely. The short story is that they don't want this type of data in many cases. So how can you still have an effective marketing program? There are different types of advertising. For example, an obvious contender here for an alternative is contextual advertising. This is information based on immediate browsing activity and is not collected over time. It's not behavioral advertising. That can be effective, and it's certainly much safer when it comes to processing activities. But obviously, folks still want to do behavioral advertising, and I think the challenge here is doing it without using or disclosing health information. When we think about disclosing health information can be included in all kinds of data when we're using tracking technology. It can be included in a URL, it could be the name of an event, it could be what buckets you create on an ad platform. So it's really having a proactive compliance program to ensure that you know exactly what type of data you're collecting and having processes in place to ensure that you're not disclosing anything that would constitute health information. So again, that's scrubbing URLs, being intentional about what you name particular events, if we're talking about Pixel, and just having a comprehensive program of that prevents the disclosure of health information, because that's when the risk increases legally, and that's when you risk violating platform ad policies. When does retargeting or the use of lookalike modeling cross from smart marketing into unlawful profiling? The laws here are relatively use neutral. The question isn't necessarily what you are using it for, though that certainly matters. For example, with the purpose limitation test, the question when you're assessing legal risk starts with what type of data am I using? If that is data that is health data or data that can constitute sensitive personal information under these comprehensive privacy laws, for example, any use of them for any purpose is going to start with some level of risk. And if we're using it for something that's far outside of expectations, like perhaps advertising in some contexts, the risk there is going to be even higher. So if we're talking about retargeting or lookalike modeling, it depends on what type of information you're using for those seed audiences. Is it based on something that is very clearly and directly related to someone's health condition or diagnosis? If so, that is more risky, as opposed to something that may be more tangential in terms of what type of information relates to an individual. So how can companies stay on the right side? This is going to vary from marketing program to marketing program. In some instances, you may want to say, like, yes, this is sensitive personal information, and we're going to get consent to use that information for this purpose, right? So you have a consented data set. That's one way to address the risk. Another way to address the risk is to sanitize the information. If there's a risk that it is sensitive personal information, if it's a risk that it's health information, you can sanitize this information to make it less likely to constitute the type of information that would require consent here. So it really is going to depend between different marketing teams. There are different approaches folks can take. But in many instances, it's either going to be get consent or sanitize that information in such a way that consent is not required. So what happens if a user opts out of cookies, but tracking or data sharing still occurs? Who's accountable? The brand, the vendor, or both? And the answer here is the typical legal answer of it depends. But ultimately, who should be worried when this happens? The answer is both. If you're on a website and you have a cookie banner where folks can opt in or out of the use of cookies, they opt out and information is still sent. That's certainly a risk for the website that's hosting that information. Even if it's a third party that's still collecting that information, the processing activity, the point of collection is on your website. So in many instances, the website has pretty high risk here. The vendor, it depends on how this configuration happened, what caused the information to still flow despite the individual's opt-out. If the cookie is not behaving as it should be, if it's not complying with certain standards, there is risk for the vendor there. But most likely the area of higher risk is going to be the websites because that is the point of collection. What enforcement trends and lawsuit risks are regulators and plaintiff attorneys focused on right now? And what's one step marketers can take to reduce exposure while keeping performance data intact? So the use of sensitive information for marketing has been a hot topic for regulators over the past several years now. And we've seen that in plaintiffs' activity as well, though obviously via different mechanisms. Regulators have their own authority, and plaintiffs' firms have to find laws to pursue causes of action under. And kind of the most common laws we've seen on that side of things is via wiretap laws and other laws that have private right of actions, for example, the Video Privacy Protection Act. But the common theme here is the use of sensitive personal information, primarily in the health sphere, but to some extent in the financial industry for marketing purposes. So what's one step you can take? I'd say the first and most important step is to have a really comprehensive understanding of what type of tracking technology and other advertising tech you have on your site, and knowing what information that technology is collecting. That's the first step to an effective compliance program. That's the first step to introducing mitigations that would allow you to continue marketing while lowering your risk. And it's the first step to building a really effective, compliant marketing program in the health space.